Hi, this is Beth Kristensen, Real Property Management Integrity, and today is March 31st, and I wanted to come to you because so many new orders and potential laws are coming into effect right now, and I wanted to update you, the owners, as to where we are. Obviously, tomorrow is the start of rent payments. We have received already a handful of rent payments. Tomorrow will be the big telltale, and of course ending on the 5th as to who has paid rent. We are going to notify our owners the minute that the rent is paid so that you are in the know, and it can hopefully eliminate a little bit of stress in your life for a day or two. So I wanted to let you know that. On Sunday morning, I had received notification that Riverside City Council was going to hold a meeting today, March 31st, to discuss doing a larger or longer moratorium on evictions. I have contacted our Riverside property owners and had asked them to submit a letter to the City Council through the city clerk, and I've reached out to other property managers and real estate agents in this community to ask them to do the same thing, because we need to stop that. That cannot be something that is going to be one-sided, that is being allowed to happen in Riverside. So I will let you know how that goes after the city council meeting tonight. But we did get a letter from our attorney, and I want to basically pass on that information to you. Governor Newsom had passed a second executive order implementing additional eviction protection for tenants who are unable to pay their rent as a result of the coronavirus. The second order states that an unlawful detainer action is filed against a tenant for non-payment of rent, and the tenant notified the landlord with at least 7 days after the rent became due. So a tenant has to let us know by April 7th that they are not able to pay the rent because of the COVID. And they also have to state why. What's the reason? Were they unemployed? Are they furloughed? Were their hours cut? The tenant will have 65 days to respond to the unlawful detainer complaint instead of the usual 5 days. So if we serve notice on the 3rd, and we go to our eviction attorney, turn in all the paperwork, they file the notice, and typically it's 5 days for the tenant to respond. This law is stating they will have 65 days to respond to the unlawful detainer complaint, and no writ to enforce the sheriff lockout will be enforced. The order requires that the tenant to retain verification of the COVID-19 related financial hardship, which may be provided to the landlord no later than the time upon payment of the back due rent. And so basically this is saying that they don't need to prove it to us until the time that all their rent is due. The governor's order states that these protections shall stay in place until May 31st. So again, we cannot file an eviction charge until after May 31st. Then it's stating that they would have 65 days to respond to our eviction. What they're saying now next is that if the local areas are doing a moratorium, then those are going to, whichever one's longer is going to take place. So it says these local moratoriums are intended to prevent landlords from serving a non-payment of rent notice or filing an eviction against a tenant when a COVID financial hardship exists. The governor's newest order provides certain protections to tenants after an eviction has been filed if the tenant meets a criteria list in order to stop the eviction. So the first question here is, do I have to offer a tenant an option to defer the rent statewide? In order for a resident to qualify for a rent deferral in accordance with the governor's original order, a local moratorium must have passed, which provides such protections to the tenant. So if the city in which your property is located does not pass a moratorium, then we're good to go. We do not have to abide by this. If they do pass it, like Riverside City is trying, then we have to abide by this. If no local eviction moratorium has been passed, the landlord is not required to offer a rent deferral to the tenant and is able to file an unlawful detainer after expiration of the pay or quit notice, subject to court closures or delays. Again, I don't see that our courts are going to open in anytime soon, so we wouldn't be able to do anything until that's the case anyways. Once the unlawful detainer has been filed, the governor's order does apply. So pursuant to this order, the tenant notified the landlord within 7 days after the rent became due that that their financial hardship was COVID related. The tenant would then have 65 days to respond to the unlawful detainer. And no lockout can take place prior to May 31st. So let's just say the courts open on April 15th. We file everything. We cannot do any evictions before May 31st. But honestly, how we're seeing the courts go with the stay-at-home orders, I don't see the courts opening until May 1st. We would file everything on May 1st, and we would have 65 days to allow them that time period to respond. So that's kind of where that's where we're at. Obviously, that's if there's no local ordinance. If there is a local ordinance, then that one will take precedence. I know Riverside City is talking about a 4-month moratorium. LA County just passed one where the tenant would have up to a year to pay back their deferred rent. So then we come into the issue of how long is our leases out for? Are they still in a lease? Because if they're done with their lease and they move out, chances are we're not going to be able to collect that. So we're working closely with the attorneys. We're working closely with city councils to determine what kind of protection we can get for our landlords. Anyways, want to let you know, we really appreciate you guys. Thank you very much for all that you, all the trust that you put in us, and just know that we are working very hard to protect your rights and to protect your rent. And we will be in touch with you soon. Have a wonderful day.